Welcome to the Ask Junior Daily Judgment podcast. I'm Priya Sharma, and joining me today is Arjun Gupta.
Hello, everyone. We're excited to dive into today's important judgments. But before we begin, don't forget to like, subscribe, and share our podcast if you enjoy our daily legal breakdowns.
That's right. Your support helps us reach more listeners and continue providing in-depth analysis of the latest court decisions. Now, let's get started with today's case. Today's case is MS Arif Azim Co. versus MS Micromax Informatics FZE, a recent judgment from the Supreme Court of India. This case involves a dispute over a contract for the distribution of mobile handsets in Afghanistan, and it raises some crucial questions about the role of international arbitration agreements.
To understand the case, let's break down the facts. In 2010, MS Arif Azim Co. the petitioner, and MS Micromax Informatics FZE, the respondent, entered into a consumer distributorship agreement. This agreement essentially gave Arif Azim the right to distribute Micromax mobile handsets in Afghanistan.
The agreement also included an arbitration clause, which is crucial here. This clause specified that any disputes arising from the agreement would be settled through arbitration in Dubai, governed by UAE law.
Essentially, the parties decided to bypass the Indian courts and instead have their dispute settled by an independent arbitrator in Dubai. This is common in international agreements where parties are from different countries and want a neutral venue to resolve disputes.
Now, the real issue arises when we look at what happened after the agreement was signed. From 2010 to 2012, Arif Azim distributed Micromax handsets in Afghanistan, but a dispute arose in 2012 over an outstanding credit balance of US $88,425 in Arif Azim's favor.
This is where the arbitration clause comes into play. Arif Azim sent a notice to Micromax, invoking the arbitration process as outlined in the agreement. When there was no response, Arif Azim filed a petition in the Indian Supreme Court, seeking the appointment of an arbitrator.
Here's the crux of the matter. Arif Azim argued that Indian courts had jurisdiction to appoint an arbitrator, relying on a non-exclusive jurisdiction clause in the agreement. This clause allowed either party to file a claim in their respective home countries, in addition to the designated arbitration venue.
Micromax, on the other hand, countered that the seat of arbitration was explicitly designated as Dubai, meaning Indian courts had no jurisdiction. They maintained that the arbitration should proceed exclusively in Dubai as per the agreement.
This brings us to the legal questions at the heart of this case. First, is the petition filed by Arif Azim under Section 11 of the Arbitration and Conciliation Act, 1996, maintainable? Second, does Part 1 of the Arbitration and Conciliation Act 1996 apply to this arbitration agreement? Third, what is the actual seat of arbitration as per the distributorship agreement?
To answer these questions, the Supreme Court delved into the complexities of international arbitration and the applicability of Indian law in such scenarios. Let's break down the court's reasoning step by step.
On the applicability of Part 1 of the Arbitration and Conciliation Act 1996, the court stated that Part 1 is applicable only when the arbitration takes place within India or the governing law of the arbitration agreement is Indian law.
This is important because Part 1 essentially gives Indian courts power to intervene in arbitrations within India or governed by Indian law. But in 2012, amendments were made to this act. The amendments stipulated that for agreements executed after 2012, Part 1 is not applicable if the seat of arbitration is outside India.
This essentially means that if an agreement specifies a foreign seat of arbitration, such as Dubai in this case, the Indian courts are unlikely to intervene unless there are specific reasons to do so.
Now, the court went further and clarified that even for agreements executed before the 2012 amendment, Part 1 would be excluded if the seat of arbitration was explicitly designated as being outside India.
This means that even if the agreement was signed before 2012, the court will respect the party's intention to have the arbitration in a specific foreign location, as long as it's clearly stated in the agreement.
To understand this better, think about it this way. Imagine you and a friend are in a car, and you agree to stop for a drink at a specific location. The location is clearly agreed upon, and both of you have a map. You can't then change your mind and say, oh, I actually want to stop somewhere else. It's the same with the seat of arbitration. The parties clearly chose Dubai, and the court upheld that decision.
This brings us to the next key issue, determining the seat of arbitration. Here, the court adopted what is known as the Shashoua Principle.
The Shashoua Principle prioritizes the venue designated in the arbitration agreement, along with the curial law applicable to that venue.
Essentially, the court looked at where the agreement said the arbitration should take place and what law should govern the arbitration process. In this case, the agreement clearly specified Dubai as the venue and UAE laws as the governing law.
The court rejected the closest connection test, which had been used in previous judgments. This test looked at factors like the location of the parties and the subject matter of the dispute to determine the seat of arbitration.
The Supreme Court reasoned that when a venue is designated alongside a specific curial law, like the UAE arbitration rules in this case, that venue should be recognized as the juridical seat of arbitration. In other words, if the parties clearly chose a venue and a specific law, it's the juridical seat, not just a random location.
So since the agreement explicitly designated Dubai as the venue for arbitration and UAE laws, the court concluded that Dubai was indeed the seat of arbitration.
This brings us to the final issue, jurisdiction. The court held that the determination of the seat of arbitration is fundamental in establishing the jurisdictional boundaries for any legal proceedings related to the arbitration.
In simpler terms, the court emphasized that the designated seat of arbitration confers exclusive jurisdiction to the courts of that location. In this case, it means the courts in Dubai would have sole authority over any arbitration-related matters.
The court also clarified that the non-exclusive jurisdiction clause in the agreement couldn't override the jurisdictional authority established by the designated seat.
Think of it like this. You're driving a car and have a designated route to follow. You can't just decide to take a detour because you like a different scenic route. The designated route remains the primary path, even if you have the option to deviate. The seat of arbitration is the designated route, and the non-exclusive jurisdiction clause is the optional detour.
This means that with Dubai recognized as the seat of arbitration, Indian courts lacked jurisdiction over the matter.
As a result, the Supreme Court dismissed Arif Azim's petition, affirming that the seat of arbitration was not in India, and the arbitration agreement was not governed by Indian laws.
This judgment reiterates the critical importance of clearly defining the seat of arbitration in international agreements. The court emphasized that the jurisdictional authority conferred by the designated seat is exclusive and cannot be undermined by any non-exclusive jurisdiction clause in the agreement.
In essence, when parties choose a specific venue and governing law for arbitration, they are delegating exclusive authority to the courts of that jurisdiction to oversee the process. This ensures that international agreements are respected and that disputes are resolved in a predictable and transparent manner.
This judgment also has implications for future cases involving international arbitration agreements. It provides a clear framework for determining the seat of arbitration and clarifying the respective jurisdictions of national courts and designated arbitration venues.
The court's adherence to the Shashoua Principle and its emphasis on respecting the parties' intentions as expressed in the agreement are significant developments in the field of international arbitration law.
This case highlights the increasing importance of international arbitration in the globalized world. It also emphasizes the need for clear and unambiguous arbitration clauses in agreements, particularly those with international dimensions, to avoid potential disputes and ensure effective dispute resolution.
And that wraps up our analysis of today's judgment. We hope you found our discussion informative and engaging.
Before we sign off, we'd like to remind our listeners once again to like, subscribe, and share our podcast. Your support means the world to us and helps us continue bringing you daily updates on the most important legal decisions.
Absolutely. And don't forget to tune in tomorrow for another exciting episode. Until then, this is Priya Sharma.
And Arjun Gupta signing off. Thanks for listening to the Ask Junior Daily Judgment podcast.